agricultural enterprise on a 2-acre piece. You'll have a house and that's it. And the 78-acre piece, which Mr. Hintermeyer farmed until 2010, and then due to health issues, including a bout of cancer, he's been unable to farm since then. But his health has improved, and he's going back and will farm again hay and cattle. What we're doing is taking a piece that can't be farmed and a piece that he's already farming, adjusting the boundaries so that they're both 40s. That's consistent with the parcel sizes on the property surrounding his. As I indicated in my letter, the uses on the property surrounding Mr. Hintermeyer's are a mix of farm and forest, hay production and cattle being the primary, and Christmas trees being the primary farm uses. So essentially, Mr. Hintermeyer is proposing to do the exact same thing on the exact same size parcel as his neighbors are doing. Okay, so we take a 2-acre piece that can't be farmed and a 78-acre piece that is farmed, and we'll convert those to 240s, which are the size of the farms around him, and will be farmed in this exact same way that the neighbors are doing. So we think we've met that criteria. Sub B applies to land that's predominantly in forest use. Mr. Hintermeyer's property is predominantly in agricultural use, not forest use, so that criterion is inapplicable. Sub C applies when you have one or more parcels that are larger than the minimum parcel size. Again, we have a 78 and a 2 in an 80-acre zone, so both parcels are smaller than the minimum parcel size, so sub C doesn't apply. And then sub D applies when you have when you could potentially, as a result of the partition, increase the number of dwellings. Mr. Hintermeyer has been approved for 2 dwellings, one on the 78 and one on the 2. Whether we go from 78 to 2 to 40 and 40, he'll still have the ability to have the one dwelling there and the ability to create a new one. So he's not, the partition or the lot line adjustment doesn't have anything to do with the creation of new dwellings. So that criteria we meet. So with that, I would, just from the policy perspective, I completely agree with staff. I think the approval was appropriate here. I agree with the board, and I would hope that the board would take into consideration not just whether or not we're correct on the law, because I obviously think that we are, but also the impact that this would have on the applicant in this case and the applicants in the following case, and the fact that these are essentially, the 2 applicants in this case are essentially the last 2 applicants that will ever be trying to do what we're trying to do in this case. So with that, Mike, you have anything you want to add? Tell them who you are and your
my
address.
name is Mike Hintermeyer. I reside at 13501 Northwest Ford Road, Gaston, Oregon. It's been a challenge ever since I bought the property, realizing in the beginning I had 3 parcels, never dividing it into tax lots, but having the opportunity to do so in the future. But then laws took effect, which I wasn't aware of at the time, where the law had changed to 1 dwelling to 80 acres. Then Measure 37 came in, and then Measure 49 came in, which I promptly took advantage of the situation and filed for my lot divisions. So consequently, because I waited for that period, I've lost 1 parcel out of the 80 acres. Instead of having 2 20s and a 40, now I'm just restricted down to 1 dwelling or 2 dwellings on the 80 acres. So I filed for this program here that I'm working under now to take advantage of, dividing the property into 240s. I don't see the 2-acre piece being advantageous to anybody living out there, being surrounded by greater acreage, which has been expressed by Dave, 40 acres around me and a couple of 20s. Like I said, it's just been challenging to acquire all this with all this formality that's going on. I think beyond that, I think Dave expressed my feelings real well, and I hope that you consider that what he said to recognize that, give me what's due. I mean, I've waited that long since '77. I want to take advantage of maybe dividing the place up and selling a piece off and looking for a better retirement period and downsizing. So with that, I think I appreciate your time listening.
Thank you. Thank you, Mr. Honeycutt. Thank you, Mr. Hintermeyer. This time we'll hear from the opponent, Sid Friedman. Mr. Friedman?
Chair Starrett, but we are not the appellant. Friends of Yamhill County is not the appellant in this case. We are an opponent, but if you'd like me to go first, I can do that.
I think you should take it from the appellant.
Take the appellant.
Yeah.
Okay.
I think you should take the appellant first.
Okay, yes. Well, no, sorry about that. Let's take the appellant first. Okay.
Good morning, Chair Starrett and Commissioners. I'm Diane Lloyd. I'm with the Oregon Department of Justice here on behalf of the LCD, acting as the weight of the state that Mr. Honeycutt described. I won't take as long as Mr. Honeycutt to explain our position. We think it's a bit more straightforward than what he described. Measure 49 was a unique compromise adopted by the voters. It granted landowners with successful claims the ability to establish home sites of 2 or 5 acres on resource lands where those home sites would have not otherwise been allowed. Mr. Hintermeyer had a successful claim and was granted a home site, in this case of 2 acres, because of his high-value property. Measure 49 and the final order that granted that home site required that acreage limitation. When Measure 49 was enacted, it included a provision with that limitation, and then also in that same section, Section 11 of Measure 49, a provision stating that the authorization would run with the land. This was to allow the unique status granted by the home site authorization to apply to the property long term. It allowed transferability, and it required certain things in exchange for that. It also granted status as a permitted use, but the conditions in that authorization, conditions such as the acreage limitation and the requirement that the parcels be clustered if there was more than 2 new home sites granted, applied to the property long term, the idea being that the remnant parcel size would be maximized to allow that parcel to be suitable for future farm and forest uses. Correspondingly with Measure 49, the recording statute was amended to allow those final orders to be recorded with the property, like an easement or any other thing that runs with the land, so that future landowners could be on notice that that limitation applied. Back in 2012, when questions about lot line adjustments came up, I provided and the agency provided advice to the counties that these restrictions, conditions to Measure 49 home site authorizations applied long term. In that advice, we did not talk about ORS Chapter 92 property line adjustments like Mr. Honeycutt described, because they simply don't apply in these unique circumstances where you have a final order that continues to apply to the property. Some folks, including Mr. Honeycutt, seem to think that there was a loophole here that was closed upon amendments to Chapter 92. Chapter 92 was amended last year by the legislature. Those amendments were brought by DLCD to update some of the language in Chapter 92. Along with that, they included a provision stating specifically that property line adjustments were not allowed to measure or to properties that were subject to a waiver. And staff testified at that time, and it's in the legislative history, that they were doing this not because the final orders didn't continue to apply to the property, but because there was concern that there was some misapplication of the provisions in Chapter 92. So it wasn't the need to close a loophole, it was just extra insurance to make sure that this wouldn't happen. DLCD is not always getting notice of these lot line adjustments when they affect Measure 49 home sites, even though the laws, the statute, Measure 49, and DLCD rules require notice. And so we're just not able to keep track of all these, and so we wanted to put that in the law for extra notice that those orders do continue to apply to the property. There's been some mention of the language in Measure 49 being specific to new parcels or the creation of parcels. That new term is in there to distinguish the Measure 49 home sites from the remnant parcel, which of course could not be 2 or 5 acres. There had to be that word in there to explain that, but there would be no reason to have a temporal sort of limitation that would allow a limitation or require a limitation with no, with no express interest in having it continue. This idea of a loophole where you could come in, apply for your Measure 49 petition, and then the next day change the lot size to be, lot or parcel size to be whatever you wanted, just wouldn't make sense. And the law shouldn't be interpreted in a way that doesn't make sense. Mr. Huddycutt also mentioned that this is, these are unique circumstances that won't continue, and so there's not a concern about this coming up again, that this can just be approved in these couple of unique cases. Our position is that the law should be applied consistently and that these Measure 49 home sites are unique. Additionally, we're concerned about what happens when someone comes in and applies for their dwelling on these parcels. When that's done, the county has to certify, they look at the final order again and make sure that the dwelling will be created consistent with that final order, and that final order has that condition that the lot be 2 or 5 acres. And so it's unclear to us how a dwelling can then be established if that hasn't been done yet. In this case, it sounds like it hasn't, on a lot or parcel that's not consistent with the final order. So that's sort of a side note, but something else to consider, and another reason that we wanted to talk about this case. So I think that's all. Thank you.
Thank you. All right. Mr. Friedman?
Thank you, Chair Sterrett, Commissioners. Sid Friedman, Friends of Yamhill County, Post Office Box 1083 here in McLeanville. I'd like to begin by pointing out what's not in dispute here. What's not in dispute is Mr. Hintermeyer's ability or right to partition the property into a 78-acre parcel and a 2-acre parcel and receive a home site, an additional home site on that 2-acre parcel. That's an extraordinary right to develop an extra parcel and an extra dwelling that would otherwise be prohibited under current zoning ordinances. What is in dispute here is whether or not the lot line adjustment enlarging the parcel, the 2-acre parcel to 40 acres is allowed. And similar, as Ms. Loy explained, I'd also like to just take a little exception to something Mr. Honeycutt said or implied, and that is that, well, this only applies to a few property owners. We don't need to really pay too much attention to it. And really, the question is whether this lot line adjustment and the following lot line adjustment are legal or not. If they're not legal, they must be denied regardless of how many property owners are affected. We agree, Friends of Yamhill County agrees with the department that the lot line adjustments are illegal for the reasons that they explained more eloquently than I can. But I'd also like to point out Friends of Yamhill County's position that even if they could be approved, the enlarged parcel would no longer be eligible for a dwelling and a building permit because it would not comply with the final Measure 49 order, which is recorded and runs with the land. So in a way, they'd be undercutting their own ability to put a dwelling on it. Finally, I just touching very briefly on the local ordinance provisions that require any parcel enlarged or subject to a lot line adjustment to be as suitable for or as appropriate for the continuation of commercial agriculture. That intent of that provision is very similar to the intent of the limitation in Measure 49 that limited the new residential parcel, the non-farm parcel, to 2 acres or 5 acres in some cases. And the idea behind that, or the intention behind that, was so that the largest possible remnant parcel remained in resource use, so that you weren't you weren't reducing the large farmable parcel down from something that in this case is very, very close to the minimum lot size of 80 acres down to half the minimum lot size. So in closing, I'd just like to ask one thing. Mr. Honeycutt requested that the record remain open until March 21st as an open record period. I'd like to request that if in fact you do leave the record open, that you grant an additional time for rebuttal for any new evidence that might come in, and I would ask that that runs through April 1st so that there's 11-day, so that they're similar in length. And with that, I'd answer any questions or sit down. Your pleasure.
All right. Thank you, Mr. Friedman. I have no questions.
Thank you.
Okay, thank you. At this time, we have public agency reports.
There were no additional public agency reports.
Any further rebuttal? Staff recommendation? I'm sorry, Mr. Honeycutt, did you have a rebuttal?
Time for rebuttal.
Okay.
Thank you, Madam Chair. Dave Honeycutt, for the record. Just a couple of brief points. The state takes the position that 92-192 doesn't apply. Oregon law prohibits a court, or you acting as a quasi-court in this case, from inserting words that don't appear in a statute or omitting words that appear in a statute. When you interpret a statute, you have to read it. The legislature sets the policy. They tell you what the statute says. You read it, and if it applies, it applies. And there is no way that you can read 92-192, which was enacted the year after the legislature sent out Measure 49, as being inapplicable here. It applies to any property line adjustment of 2 parcels which are smaller than a minimum parcel size in the zone. It doesn't exclude Measure 49 parcels. If the legislature wanted to exclude Measure 49 parcels, they certainly could have done so. It's the same people. They didn't do that. And so the state's argument is completely undercut by 92-192. It's not that it doesn't apply. It completely undercuts the state's argument. Mr. Friedman indicated that my comments were essentially on the policy point, were essentially that you don't need to pay attention to the law just to prove these because it only affects a couple of people. I'm not saying that at all. I want you to pay attention to the law. I want you to rule in accordance with the law. My comments weren't directed towards Mr. Friedman or the Friends. They live here and are in the area. I understand why they might have an interest in this case, although I think it's misguided. They live here. My comments from the policy perspective were directed towards the state, where you have a state agency with limited resources spending its time on a case that impacts 2 people. Okay? 2 people here and 2 people in Polk County. This is an argument I really should make to the legislature, and I will, not to you. But I don't think that's an appropriate use of state resources to come in and essentially wait until the very last two Measure 49 claimants with property line adjustments come along and choose those two people to have a fight over an issue that, for all intents and purposes, is now dead. That's what I was trying to say with my comments.
All right, thank you, Mr. Honeycutt.
Thank you.
Do we have a motion to continue?
We're actually working on some of the dates for that.
24th?
To maybe read off a motion. I just wanted to ask, Mr. You're asking until March 21st. Typically, we give 1 week, 1 week, and 1 week. And 1 week for all parties, 1 week for all parties to rebut, and then 1 week for final written rebuttal. Is that a schedule that would work for you, or is it something?
That's actually for the final word, you meant.
Yeah.
Yeah, I can do that. I would prefer to go till the Monday, which would give me all of next week to address a couple of the letters that were addressed. However, if the board would prefer, the 7th works for me.
Madam Chair, I just wanted to ask if you have a problem with Mr. Friedman's request for rebuttal till April 1st. If
No,
you
no,
don't,
no.
then we would just give you 1 more week, or I would suggest that we give you 1 more week for your final word, and then bring it back for deliberation that following Thursday.
Certainly.
Which is April 13th. Is that?
I think this is-
14th.
Okay.
So I think if you want to suggest that the motion and see if you've.
Okay. So, I'm sorry, I just want to check before I read this. March 21st, April 1st, then April 8th. Okay.
April 7th.
That's
But-
fine.
April 8th is fine.
The
yeah.
last week really, is
We're
for the
off
board to
because
read
of-
it, so.
Yeah, April 8th for final word. So,
This is my suggestion, Commissioner. The record shall remain open until 5 p.m. on March 21st, 2016, for all parties to submit written testimony or evidence to the Planning Department at 525 Northeast 4th Street, McMinnville. The record shall then be open until 5 p.m. on April 1st, 2016, for all parties to submit to the Planning Department written rebuttal to what was submitted during the first open record period. The record shall then be open for the applicant only to submit final written argument with no new evidence until 5 p.m. on April 8th, 2016, and at that point, the record shall be closed. The Board of Commissioners shall then reopen the hearing at 10 a.m. on April 14th, 2016, in room 32 of the county courthouse at the point of staff recommendation.
All right, do we have a motion to continue?
I would move that we continue according to the schedule just set forth by Mr. Friday.
All right. All right, we have a motion to continue with the final vote on April 14th. All those in...
when the staff, yeah.
Right. Do we have any further discussion? All right, all those in favor of continuing, say aye.
Aye.
All those opposed, passes unanimously. All right, thank you. All right, at this point, we will open the public hearing for docket L45-15, an appeal by DLCD on a lot line adjustment involving a lot approved through Measure 49, applicant Robert and Betty Jansen representing the Yamhill Family Trust. Do we have any abstentions from the board? Abstentions from the board? Okay. Do we have any objections to jurisdiction?
Madam Chair, I have no objection.
Okay. Yes, sir. Would you state your name and address, please?
Madam Chair, Commissioners, thank you for the time today. Am I speaking closely
Yes.
enough? Okay.
Thank you.
Thank you for the time today. My name is Joseph Strunk. I'm an attorney with Tankersley, Wright, and Strunk here in McMinnville. Our address is 701 Northeast Evans Street. We have long represented the applicant and owners in this matter, Robert and Betty Jansen, who are also here today, as well as the Youngman Family Trust. We object to jurisdiction because we think that DLCD has failed to establish standing in this matter. I've previously submitted a letter describing our position in this regard, but I'd like to walk the board through our analysis. To establish standing to pursue an appeal, a party must comply with the requirements that are detailed in the Yamhill County Zoning Ordinance 1400. I'll read relevant portions of that to the board. 1404.03 says that a decision by the Director, Planning Commission, or Board of Commissioners to approve or deny an application or docket item request may be appealed provided the appellant has satisfied subsections 1, 2, and 3. Subsection 1 requires an appellant to file a written appeal accompanied by the appropriate filing fee. The record in this matter indicates that the appeal deadline was established consistent with the Yamhill County zoning ordinance to be December 30th, 2015. The record also reflects that DLCD filed a written appeal of this approval on December 30th, 2015. However, the record indicates that the appropriate filing fee was not received until January 4th, 2015. Copies of relevant records are included, including a receipted, an envelope stamped receipt are included with the letter I've provided to the board. These requirements are jurisdictional. The Yamhill County zoning ordinance, the provisions of which I just read you, indicate that in order to establish standing to appeal, an appellant must satisfy these requirements. Let me flip over to other relevant provisions to read to you. Reading further on in the same section, 1405.02 permits this Board of Commissioners to waive that filing fee requirement. But I'll read from the section. It indicates that upon recommendation from the director or the hearing body or upon its own motion, the board may waive for just cause any filing fee established by this section. I think failing to file the appropriate filing fee is required by the statute. The ordinance says that the appeal must be accompanied by a filing fee. In this instance, it was not accompanied by a filing fee. The filing fee was not received until 5 days later. We're not aware of anything in the record we're not aware of any request by DLCD to this board to waive that requirement, or showing of just cause for waiving that requirement, or an approval from this board to waive that requirement. Accordingly, we request that this board dismiss this appeal for lack of standing. This seems harsh, but LUBA has heard similar cases on several instances, and LUBA has upheld a county's authority to strictly enforce these requirements. Included in my comments, I referenced one case in which LUBA upheld a dismissal of an appeal that was filed 5 minutes late. Again, this seems harsh, but if we think about the slippery slope that we're creating by allowing the state of Oregon to file 5 days late, it makes sense why the county would want to strictly enforce these requirements. If we don't strictly enforce these requirements against the state of Oregon, how are we going to strictly enforce them against an unrepresented party who comes in a day late and wants to file a similar appeal? We just heard from the DLCD representative that DLCD is concerned with consistently applying laws, and I think in this instance that holds true. We shouldn't give the state of Oregon more leeway in complying with our filing requirements than we do any other individual in this county. I assume that the DLCD would like to be heard on my request to dismiss its appeal. In that instance, I would like to reserve some time to present a rebuttal to what the DLCD presents. Thank you.
Okay, thank you. Thank you, Mr. Strunk.
Commissioners, Diane Lloyd on behalf of DLCD. Again, staff filed this appeal. I'm not sure of the details surrounding it. Perhaps your staff could explain more. I will say, though, that if this jurisdictional issue is being raised, that a procedural issue is going to be considered like this, we have one as well. The statute and rule require that DLCD get notice of decisions involving Measure 49 homestead authorizations. We did not receive notice of this decision from the county. We acquired the notice through other means. And so I think if you want to remand the decision to the director, we can do that, and then we can file the appeal again. But otherwise, I think it would be proper to just save time and decide the case on the merits. But either way you want to go would be fine. Thank you.
Thank you.
May I be heard on this matter as well, Chair?
Can I say one thing?
Yes,
before?
Mr. Friday?
I just wanted to note that the December 15th, 2015 letter that approved the lot line adjustment, there is a CC to the Board of Commissioners, Assessor's Office, Public Works, DLCD, and surrounding property owners. So we did send notice to DLCD on this lot line adjustment, and we have sent notice on all farm and forest lot line adjustments to DLCD.
What was the date on that, Ken?
December 15th, 2015.
Thank you. Yes.
Very quickly, I've been advised by staff that they did not receive notice, and they've checked with everyone in the office who would have received notice. But that's all I know. Thank you.
Thank you.
Thank you. Mr. Friedman?
Chair Starrett, Commissioners, I want to address something that Mr. Strunk said, and that is, Mr. Strunk said that DLCD filed the appeal 5 days late, that they filed 5 days late. That's simply not true. The appeal was filed on a timely manner on December 30th, prior to the appeal deadline, and the payment was received by the department shortly thereafter on January 4th. It's my understanding that that was done with staff's knowledge. Perhaps your staff can illuminate that. At any rate, the board certainly has the authority, and I believe it would be well placed to allow this appeal hearing to go forward today, rather than put the applicant and other parties in the position of having to go up and down on jurisdictional issues, only to have it wind back up in front of you at some point in the future. Thank you.
Thank you. Mr. Strunk?
Thank you for the additional time. I find it curious that if the DLCD did not receive notice of this appeal, why it filed an appeal on December 30th, which was the deadline indicated in the notice. But again, even if DLCD does have a valid procedural issue, as was just suggested, it was not raised by December 30th, 2015, and I think it was waived. Mr. Friedman did not accurately paraphrase my argument, and forgive me, maybe I didn't make it accurately enough. Let me refer directly to the zoning ordinance to which I referred. And again, I'm reading from Yamhill County Zoning Ordinance 1404.03. And this is the requirement to establish standing. An appellant must file a written appeal I think DLCD did that. It appears that they gave a written appeal by December 30th. But it also requires that that appeal be accompanied by the appropriate filing fee. And it was not. Both of those are requirements to establish standing, not just filing an appeal. I believe it was suggested, if I heard correctly, that staff was aware of these requirements. I believe that may have been the case, but I don't think we want to adopt a policy whereby the state of Oregon not only gets away with not complying with our ordinances and requirements, but also expects our county to advise it on legal matters. And I think that was what was suggested by that comment, if I understood it correctly. I'm happy to answer questions or provide further argument on this. I think if the commissioners review the cases I've cited, I think it's clear LUBA allows a county to strictly enforce its filing requirements, even if an appeal's filed 5 minutes late. Part of that filing requirement is the payment of a filing fee. The cases I cited don't only discuss filing a piece of paper, they also discuss providing the appropriate filing fee with that if it's required by the ordinance, like Yamhill County's ordinance requires. Again, I don't see a reason to allow the state of Oregon to file 5 days late, file its required filing fee 5 days late, especially if we expect to enforce this requirement, which is clear in our ordinance with citizens in the future. Again, I'm happy to answer questions, discuss this further, but I'll repeat my request that the Board of Commissioners dismiss this appeal for lack of standing.
Thank you, Mr. Strunk. Mr. Honeycutt, did you want to comment?
Thank you, Madam Chair. Dave Honeycutt, Oregonians in Action, new case, PO Box 230-637, Tiger 97281. Policy point here. I agree with Mr. Strunk. It's important for you to enforce the provisions of your ordinance evenly and fairly to everyone. The policy dilemma that you would create were you to allow DLCD to file the payment for the appeal late are multiple. Number one, is 1 day late okay? Is 5 days late okay? Is 2 weeks late okay? You would have to set some kind of standard that's outside the language of your ordinance for how long anyone would have, including the state, to file a late notice. Conversely, requiring the appeal fee to be paid at the time that the appeal is filed ensures that both staff and the board aren't running around trying to collect for the appeals that are made and scheduling hearings and spending time and effort and money on appeals where the payment may never be received. Okay? So it's important that it seems to me that you require that the payment be made. It doesn't necessarily have to be made simultaneously with the appeal, but it needs to be made before the appeal deadline expires so that staff isn't out spending time chasing after money on an appeal that really shouldn't be brought. The second point, policy point for you, unlike the other issues in this case and the previous case, this is an interpretation of the Yamhill County ordinance. You are the final decision makers in your interpretation of the Yamhill County ordinance. And LUBA will not overturn your interpretation of your ordinance unless it's clearly wrong. The interpretation that Mr. Strunk asks you to make of your ordinance, I think is accurate, number one, and it's certainly not clearly wrong. While there may be other arguments that can be made about what it means, the interpretation that he's asking is not clearly wrong. So Mr. Friedman's argument that we would yo-yo back and forth, and we might as well get to the merits so that we avoid yo-yoing back and forth to LUBA and back down, I think is misplaced. If you dismiss and a LUBA appeal is filed, LUBA will not overturn your interpretation of your ordinance. It's your ordinance. It's not state law. It's not LCDC administrative rule. LUBA will not overturn your interpretation of your own ordinance unless it's clearly wrong. And if you read the LUBA cases, it's a very high bar. LUBA rarely overturns a county's interpretation or a city's interpretation of its own code. They leave that to you, which is precisely where it ought to be.
Thank you, Mr. Honeycutt. Mr. Sadlow, could you comment at this point on the proceedings?
Yes, Madam Chair, we do have, or would you like to hear from the Planning Department as well first? Or
You want to hear from me?
Yes.
Since I'm probably the focal point of all
Mr.
this.
Brandt?
Finish it off, I guess.
Yeah, a couple things. First of all, I want to address the issue of whether or not the county provided notice or whether we do on lot line adjustments. We do, and we have from the beginning of time on lot line adjustments given notice to DLCD. And in fact, on this particular application and the Hintermeyer application, I asked my staff to make sure, because we were coming up to the deadline of the calendar year and the new statute going into place, I said, let's make sure that this gets to the LCD. So as Mr. Friday read, they were CC'd on the letter. I don't know what happens to it after it leaves us, but we do provide notice. And it bothers me that they're suggesting that we didn't do that. Regarding the appeal and the fees, I'm going to accept full responsibility for the filing fee being filed late. I spoke to a young man by the name of Matthew Kroll on December 29th of 2015, in which he expressed that DLCD was thinking about appealing the application. He wanted to come over to our department with up to 5 staff members and talk to me about how our decision to approve the Jansen lot line adjustment was in violation of state law. We talked on the phone for a while. I said I really wasn't interested in being lectured by 5 people from the state, that we stood by our decision, and that I would like to sit down with them at some future date and talk about that decision. He thanked me. He then called me back later in the afternoon on the 29th and said that they were going to go ahead and file the appeal. He asked me then if they could go ahead and send the check for the appeal by mail. I said, yeah, that's fine with me. I followed up with an email, I think, to a Sarah, I can't think, Marvin, yeah, on the Hintermeyer application, in which she said, we're sending a check for Hintermeyer, and I sent her a follow-up email that said, I only said for the Jansen application, and it was my understanding that they were cutting the checks on the 29th, that they would be put in the mail on the 29th, and in my email I suggested that it was our expectation that they'd be received by the 30th, which would have been the appeal deadline anyway, understanding that there was the possibility that there could be problems with the U.S. Post Office getting there, just like apparently our notices aren't getting to them. All that having been said, as I said, I take full responsibility for this. It was my decision to say that they could do this, but the ordinance is clear. And this isn't a gotcha moment that Mike Brandt said, aha, this is a way to do it. In fact, my much wiser planning division manager on the day when I said that said, we probably should call him back and say this check needs to be here by the 30th. And I said, no, I'm not really worried about it. First of all, I thought it would be there by the 30th. Secondly, I really thought that if we sat down with our staff and DLCD staff, and including the Department of Justice staff, and we talked about this in light of the new legislation that was going to be in effect on January 1, that this would probably not be appealed, that they'd withdraw their appeal. I also felt that even if it was appealed, that if it got before the Board of Commissioners, they would look at it in the same way that the staff has and say, this case wins on the merits, and that would be the end of it. Having said all that, again, it's my responsibility. I did say that to the DLCD staff, and I want to apologize to the Jansons as well, because they've been put through this, and they're two of the best people I've ever met in my life, to be honest with you. They sent their attorney shortly after the notice went out and after the appeal came in, and they wanted to make sure that I wouldn't be thrown under the bus if they filed an objection to the jurisdiction based on the late filing of the appeal fee. And I told them, don't worry about it. I mean, I'm a big boy. I'm the one that made the decision. And I've never done it before. I never will do it again. And I don't recall ever being asked to do this before, and certainly not by a state agency. But I wanted that to be out in the record for background so that the appellants know what's going on, that this wasn't a gotcha, and that the applicants know what's going on, that this wasn't something to mislead them as well. So,
Thank you.
May I ask a question?
Yes.
Yeah. Mike, you indicated that the lady you talked to, Sarah, at...
that was just email with Sarah Martin.
Oh, okay. But she indicated they were sending the check for Hintenmeyer on that day, and was no mention made of the other check?
No, they'd already
You
sent that
said
one.
something to her at that time, did you
Right.
not?
What happened is she sent an email that said, I understand you talked to Matthew Kroll about mailing the check in, and she put the Hintermeyer docket on there, and there may have been the Jansen docket as well. And I wrote her back an email explaining that I was only talking about Jansen because Hintermeyer's appeal wasn't due until January 4th,
Okay.
which is when the check came in anyway.
Okay.
The Jansens was due on the 30th, and I made it clear to her, I said, this is a one-time thing. I'm expecting it to be postmarked on the 29th, and I fully expect it to be received by the 30th. But again, I understood that they couldn't control the U.S. Post Office.
Okay. And they're fully aware of our ordinances in their offices, I'm sure. And if I'm not mistaken, what I heard said, our ordinance indicates that this board is the only jurisdiction that has authority to waive that fee or to compromise the timing.
Right, and really to interpret the ordinance.
To interpret the ordinance. Madam Chair, unless it's out of line, I would...
Well, if I would first, I would just want to comment on some of the comments that were made, and that is that we do have two sections that say written appeal shall be filed with the director within 15 days of the decision and shall be accompanied by the appropriate filing fee. And then under the section on standing to appeal, provided that the appellant has filed a written appeal accompanied by the appropriate filing fee with the director, the standard for your deference that you're given in your interpretations of your own ordinance has shifted over the years. It actually was clearly wrong for a long time, and now it's plausible. That's from the Cypern case. If your interpretation is plausible, and I'm not sure how easy it would be for you to make a plausible determination that this provision does not mean that you have to accompany the application with a check, and it would be plausible to do it the other way. So,
All righty. Commissioner?
Yeah, Madam Chair, I would make a motion that we dismiss this appeal based on the fact that we do lack jurisdiction. There is no standing on the part of the applicant, and therefore, be my motion that we dismiss this appeal.
We have a motion to dismiss the appeal. I would like to add an amendment to that, if I may, to allow council a week to prepare findings.
a week would be fine.
A week? Would that be?
Sure.
Okay. We have a motion to dismiss appeal of docket L4715. Do we have any further discussion?
Yeah, I've got a couple comments after hearing both sides. I find it curious in one case that Ms. Lloyd and Mr. Friedman would want strict adherence to the law in the first case, but lenience in the second case, where they clearly missed the deadline. And it seems like in our country, we have some issues about equal treatment under the law going on even as we speak today. And I can't ever remember being cut slack at a court hearing or a traffic ticket when I failed to meet the criteria. And I appreciate Mike's kind of helpful nature in this, but it's not his job to change these requirements. And I love him dearly, but that's just another observation of mine. Thank you.
Thank you, Commissioner. So we have a motion to, any further discussion? We have a motion to dismiss the appeal of docket L47-15. All those in favor of dismissing the appeal, say aye.
Aye.
Aye. Passes unanimously. So we'll close that hearing. At this point, do we have any other announcements, Commissioners? Do want to say that if anyone wants any information on County Advisory Committee vacancies, they can go to our website or call the Board of Commissioners office, and that information is on the website.
I would, excuse me, like to make a couple of comments. We did have public testimony that questioned whether we were being open with the Rails to Trails project with the adjacent landowners. I know for a fact these landowners have been contacted personally and by mail, been invited to every meeting that's been held, and many of them were in attendance when we had our charrette program going, and I attended all three of the latest meetings, and there were several landowners in attendance, so I take issue with the fact that they made it sound as if we had been doing this in the dark. This has been a very open and transparent process, so just for the record.
All righty. At this point, we'll close the Yamhill County Board of Commissioners formal session for March 10th. It is 11:43.